If that is in fact the face of a man who just brutally stabbed to death 4 college students, and he's smiling and giving a thumbs up and looking like he doesn't have a trouble in the world, that is probably one of the most chilling crime scene photographs you're ever going to see. More shocking revelations in the Idaho 4 stabbing murders, with prosecutors now revealing they have evidence of when suspect Bryan Kohberger purchased the murder weapon. Plus, a North Dakota woman stands trial for the stabbing death of her roommate nearly 20 years after the attack took place. And attorneys continue to fight tooth and nail over last-minute issues in the run-up to the murder retrial of Boston area woman Karen Reed. All this and more this week on Courtroom Confidential. The phrase, "what a difference a day makes," probably has no more accurate application than in the world of true crime, and this week was no exception. We are recording this episode on Friday, March 21st, 2025, and this is your Courtroom Confidential weekly roundup. Court documents in Bryan Kohberger's upcoming trial reveal shocking new details, including records of his alleged online purchase of a combat knife thought to be the murder weapon. Kohberger is accused of fatally stabbing University of Idaho students Madison Mogen, Zaina Kernodle, Ethan Chapin, and Kaylee Gonzalez in their Moscow, Idaho home in 2022. The potential evidence was featured in a trove of materials released Wednesday. A key standout was a revelation that prosecutors say online records exist to prove Kohberger bought a military-style knife, sheath, and sharpener about 8 months before the murders. Previously, investigators described recovering a tan leather knife sheath on the bed next to Mogen's body. Quote, "The sheath was later processed and had a K-bar USMC and the United States Marine Corps Eagle, Globe, and Anchor insignia stamped on the outside of it," a Moscow police officer wrote in his report. The Idaho State Lab later located a single source of male DNA left on the button snap of the knife sheath. Prosecutors say that DNA is a statistical match to Kohberger. The murder weapon, believed to be a large fixed blade knife, has never been recovered. Court records also include a selfie Kohberger allegedly took hours after the murders on November 13th of 2022. In the photo, Kohberger is seen smiling and giving a thumbs up, possibly in front of a tiled shower. Prosecutors intend to use the photo to highlight Kohberger's eyebrows, specifically a description provided by a surviving roommate who saw a stranger in the house around the time of the murders, dressed in all black, wearing a mask, with his only notable feature being, quote, bushy eyebrows. Kohberger's defense previously sought to exclude any mention of bushy eyebrows, calling it unfairly prejudicial. If convicted, Bryan Kohberger could face the death penalty, but his lawyers now argue that executing him would violate his constitutional rights due to his autism diagnosis. Prosecutors push back in their latest filing, arguing Kohberger's autism is the least severe form, quote, without accompanying intellectual or language impairment, and that he's failed to show how the diagnosis would in any way make him less culpable for murder. Kohberger's defense also responded to a prosecution motion seeking to admit text messages exchanged between the 2 surviving roommates as evidence at trial. The defense claims prosecutors selectively cited those texts, excluding evidence that the roommates continued calling and using their phones from 7:30 a.m. until 911 was called at 11:56 a.m. Kohberger's attorneys are now asking the judge to review the full context of the messages and to determine whether the text should be excluded as hearsay. Kohberger is due in court April 9th for another motions hearing. Well, what's happening here? Wow. For months and months, we had to deal with a near blackout of information in this case. And within a matter of a couple of weeks, it has your head absolutely spinning. You remember last week is when we received those text messages between the surviving roommates. And that was a real revelation. We got an insight as to what they were talking about, what they were up to, what they were thinking, and perhaps explaining their fear, their apprehension, and why 911 was not immediately called. And then we have the 911 call, a transcript, and the actual recording of the 911 call. Again, incredible insights into a case that for months we knew very little about because of certain orders made by the judge. Well, that has all changed. This week, Nearly in passing, the prosecution says in their moving papers that they have evidence that Bryan Kohberger purchased what is most likely the murder weapon in this case from Amazon within months of the murders. There's no way to describe it other than ground shaking. This is huge evidence. Now, the defense says that the search warrants were overly broad and that the resulting data is incomplete, and that the account used is a household account shared by Kohberger and other family members, and they complain that the prosecution is cherry-picking specific clicks or purchases out of an Amazon click history, removing all the context. I say good luck with that. The one issue that the defense was desperately clinging to in this case was that there was perhaps some innocent explanation as to why Kohberger's DNA was found on that knife sheath. And it had even come down to the argument that they were going to make that it was somehow planted there, that some other person put their client's DNA on the single most important physical piece of evidence recovered from that crime scene. In my view, this search history, if in fact true, if in fact the prosecution can prove that Bryan Kohberger purchased a K-bar knife within months of these murders, then their arguments as far as that DNA are all but dead in the water, as far as I'm concerned. There was one possibility that they could argue that there was in no way a connection between Bryan Kohberger and any type of K-bar knife, and that the idea that his DNA was found on that knife sheath is an anomaly, is unexplained, is unsupported by other evidence. This is the theatrics you could see the defense going through about that DNA. And now the prosecution's got the receipts. If they can in fact prove that he purchased a knife believed to be the murder weapon, which has, by the way, never been recovered. That's the other thing that Kohberger could do and his team. Show that he sold it. Show some sort of eBay history. Produce some sort of friend who says, yeah, he gave it to me as a gift. You show that he purchased that knife, and that knife is believed to be connected to the knife sheath found at the crime scene where 4 young people were stabbed to death, and his DNA is found on that knife sheath. What are you going to do with this case? The case is shut, closed, as far as I'm concerned. Now let's talk about this selfie. This was the other thing that was not only chilling to me, but also I think very clever on the part of the prosecution. And they used a door open to them by the defense. It was a strategic mistake made by the defense. The defense wanted all reference to bushy eyebrows kept from being mentioned to the jury. And this argument was weak to begin with because that's what the witness said. And they felt that somehow it was too prejudicial because this witness can't, in fact, ID their client. And by just saying bushy eyebrows, they're going to take a look at Bryan Kohberger, who happens to have bushy eyebrows, and the jurors will draw inappropriate references and conclusions from that. First of all, I don't think that argument tracks at all. That's the whole point of eyewitness identification. You may not be able to identify the person sitting in court, but can you identify features consistent with the person sitting in court? They certainly did not describe a short, overweight person who was balding. And then you got Bryan Kohberger, tall, lanky, bushy eyebrows. So I don't know where they were trying to go with that argument anyways, but the prosecution took the bait and ran with it. And they said, okay, you got a problem with bushy eyebrows being described in court. You say your client doesn't have bushy eyebrows. Let us produce to you what we believe is a photograph taken most close in time to when the murders were committed. Oh, guess what? Your client happened to have taken a selfie. And in that selfie, he's got bushy eyebrows. But I'll tell you what, that was not the point of this photograph. The point of this photograph is it made him look like an absolute psychopath. I am no psychologist. I am not using that term in its most technical sense. But what I saw in that photograph was someone who gave me chills. If that is in fact the face of a man who just brutally stabbed to death 4 college students, and he's smiling and giving a thumbs up and looking like he doesn't have a trouble in the world, that is probably one of the most chilling crime scene photographs you're ever going to see. Last thing on all of this. We've received a lot of information in the last few days on this case, and I don't think it's the end of it. I think what we're realizing is there is far more we don't know about this case than what we do know. And that's why I think this trial will be fascinating. I think there's far more evidence out there. There's far more linking Bryan Kohberger to this case. Now, presumption of innocence, all of these are allegations, absolutely true. But it does seem like when we start to get new evidence, that seems to be evidence that is leaning in the direction of the prosecution. But what do you guys think? Do you think that this Amazon purchase history is as devastating as it sounds to me? Please let us know in the comments. Trial began this week for a North Dakota woman accused of murdering her roommate nearly 2 decades ago. Nichole Rice is charged with felony murder in the 2007 death of Anita Knutson, who was found stabbed to death on June 4th, 2007. The two women were roommates at the time, though friends described the relationship as strained. One friend recalled Rice telling Knutson, quote, "One way or another, I'm going to get you out of this house." On Tuesday, Knutson's mother testified that Anita was afraid of Rice, so much so that she had her father install a lock on her bedroom door for privacy. It was Anita's father who ultimately discovered her body after she failed to show up for work or answer repeated calls. Evidence at the scene suggested the killer had access to the home, and police quickly ruled out robbery as a motive. Still, the case remained cold for nearly 15 years. Interim Minot Police Chief Dale Plessis, who was the first officer on the scene that day, testified Wednesday that the true crime series Cold Justice contacted MPD about the case and offered their support. Their involvement, he said, helped move the stalled investigation forward. Rice was arrested in 2022 after investigators noted inconsistencies in her statements. Thursday ended with a hearing over the testimony of Devin Hall, a prior person of interest in the case. Prosecutors maintain Hall wasn't in North Dakota the night of the murder, but the defense insists he was, and that the murder weapon matches a knife Hall claimed to have once owned. The judge ruled Hall can testify via Zoom since he is currently incarcerated at the Fort Peck Reservation. The following day, Rice's ex-boyfriend, William May, testified that at a party in 2008, a drunk Rice admitted to killing Knutson, but later claimed she didn't remember saying it. After giving a statement to the police, he cut ties with her but reconnected years later, briefly dating again before ending the relationship. Well, what's happening here? This case baffles me. But it's not because I can't figure out who did it. It's because I cannot figure out why it took the police so long to make an arrest. And I'm not saying that this case is a slam dunk. I think this case has issues and problems like any other case. But what exactly caused the 15-year delay between the murder and the arrest? It's not like they were waiting on testing. It's not like they were waiting on new evidence. It's not like they were waiting on a confession or some new witness to come forward. Now, I am all about police patience and getting it done right. I do not believe in a rush to judgment. That's not what I'm saying here. I think that, in fact, many times police don't show enough patience in bringing charges. Same goes with prosecutors. You should be able to say with confidence, I can prove this case beyond a reasonable doubt before I'm going to bring this person to trial. But I don't think that's what happened here. This one confuses me because this case also didn't get any better in the meantime. It's not like there was something that they knew now at the time of making the arrest they didn't know back then. Even if we're talking about waiting until she made an admission, she made admissions to people within a year of the murder. I imagine police had spoken to those people. I imagine the police have, right now, all the evidence that they had 10 years ago. And so I still am confused and unclear as to why it took them long to do this. And the parts that most frustrating to me about that is that it's not only not helpful to the prosecution, but it might even be prejudicial to the defense. A defendant has or should have the opportunity to defend themselves and have the evidence to defend themselves available to them. But if you wait for forever to bring charges, some of that goes away. We all know about how long surveillance video can be overwritten, or text messages can be lost, phones can be thrown out and new phones purchased. Witnesses can disappear. Witnesses can die. Things don't usually get better for the defense after that long a period of time. Same proves true for the prosecution. Things usually don't get better. And in fact, the defense can point to that, especially when you're dealing with a case where it doesn't seem as though some remarkable piece of evidence came forward years later to explain why this case took so long to get to court. If it was something like a confession finally made or DNA evidence finally recovered, something like that I can understand. But we are dealing with a person who was likely their number one suspect at the time. They talked about how there was no signs of forced entry. They talked about the motive that she had for the killing. All of those things existed back when the murder took place. So again, why did it take so long? The other thing about this case that's interesting is how much of this concept of third-party culpability the judge is allowing into this case. And we've discussed this many times before, that many times it's a judge's call as to whether or not third-party suspects' culpability, whatever you want to call it, will be allowed to be presented to a jury. And the judge is allowing quite a bit here. Now, I doubt that this other suspect, Mr. Hall, being called as a witness by the defense is going to be all that helpful to the defense. I can't imagine he's going to admit to somehow being implicated or even placing himself anywhere near where this murder took place. But conversely, think about the effect of having an in-custody witness testify will have on the jury. This was a quote-unquote person of interest at one point. This is a case that went unsolved for a long period of time, and now the person the defense is putting forth as their suspect happens to be in custody. I don't know what issues that will create. I don't know how the jury will react to that. I just know that it was a favorable decision, I feel, by the judge to allow the defense to explore this issue. But what do you guys think? Why did the police wait so long to make an arrest here? Was it patience or was it something else? Please let us know in the comments. The Karen Reed case returned to a Norfolk courthouse this week for 2 days of pretrial arguments. Amongst the many issues presented was a defense request to delay the start of the Mansfield woman's second murder trial to allow for a federal court to consider and issue a ruling on their double jeopardy arguments. Despite the Commonwealth's joining in the motion, Judge Beverly Cannoni denied the request, keeping jury selection scheduled for April 1st, citing concerns over the case's large jury pool. Judge Cannoni noted that if a jury is selected by April 25th and the federal appeals court has not ruled on the defense's effort to dismiss 2 charges, she may reconsider the delay. Reed is accused of striking her boyfriend, Boston police officer John O'Keefe, with her SUV in 2022 and leaving him to die after a night of drinking. Her defense maintains O'Keefe was killed inside a fellow officer's home and his body staged outside. This week, Judge Cannoni also ruled that the defense's 2 ARCA accident reconstruction experts could testify again. Both previously stated O'Keefe's injuries were inconsistent with being hit by a car. Prosecutor Hank Brennan had sought to block their return. Before ruling in their favor, Cannoni reprimanded Reed's attorneys for what she said were, quote, false statements and repeated misrepresentations regarding their relationship with the ARCA witnesses. Throughout the arguments, the defense and prosecution repeatedly clashed over which expert witnesses would testify, what evidence the jury would see, and whether the defense will again be able to present its theory that someone else killed John O'Keefe. Thursday's hearing also came a day after it was announced that Trooper Michael Proctor had been terminated by the Massachusetts State Police Office over conduct related to the Reed murder investigation. Proctor, who was the lead investigator on the case, came under fire for a series of disparaging texts he sent about Reed, which were read aloud in court during her first trial. In the text messages, Proctor referred to Reed as a whack job and other derogatory slurs. He talked about her medical issues and wrote, quote, "No nudes so far," when discussing searching through her phone. Proctor admitted on the stand that the texts were unprofessional. Most of the issues presented this week were not immediately decided by Judge Cannoni, who added another hearing date for this coming Tuesday to continue the work. What's happening here? Well, one other big thing happened this week in the Karen Reed case, but it didn't happen in court. Investigation Discovery released a 5-part docuseries entitled A Body in the Snow, The Trial of Karen Read. And I am beside myself with the amount of interviews, public statements, and really unfettered access that Read has given to the media in this case. It is absolutely astounding to me, and I don't understand it. I don't understand it from a strategic perspective. I guess I can wrap my head around it from Karen Read's personal perspective of wanting to have her story out there, of trying to defend herself, of wanting people to hear what she's going through. Sure, but you're on trial for murder. All those things can wait. When this case is done, you will have your opportunity to tell your story, quote unquote. But why even take the chance with risking that something that you do or say in one of these many interviews and now a full documentary will somehow come back to bite you? I just can't understand it. This documentary was filmed and produced before her first trial. So she was already okay with the idea of having herself interviewed, talking about the case, making statements about what took place that evening. I mean, that is what's more shocking to me about this. She's not saying, I'm not going to talk about that evening. That will play out in court. But I can tell you about what I've been living with. And I can tell you about how my life is now. And I can tell you about how difficult it is to be on trial for murder. But she didn't stop short. She said, I'll tell you about that evening. I'll tell you about what led up to that night. I'll tell you what happened the following morning when I discovered John O'Keefe's body. I would be shocked if this prosecutor in particular does not try to use that against her, and perhaps to devastating effect. Now, the other thing that we're seeing this week is the Canoni did not rule on much. There was a lot argued, but very few things decided in court. But what she did rule on was confounding and frustrating to me. First of all, the idea that she didn't grant a continuance here. The defense and now the Commonwealth have joined in saying, you know what, probably the better side of caution tells us to wait until after this appeal is heard and decided on by the federal court. And Judge Canoni said no. And I don't get it. Why create these issues? We're talking about a matter of weeks. We're not talking months. We're saying from the beginning of April to late April. Do you really want to go through all of this again? Do we really want to create issues where issues don't need to be created to save ourselves a few weeks worth of time? I understand it. I've lived it my entire life with judges constantly pushing to get things done. And I understand why they do it. I understand the pushback. I understand that they don't want to forever allow and grant continuances because then nothing would get done. But in this case, you have a really good reason for it. There's a court that could have a fundamental effect on this trial that's going to make a decision pretty soon. Shouldn't we wait to see what that decision is before we proceed forward? And she says, I understand why that's important, but we can still pick a jury. And if we pick a jury, we don't need to swear that jury until after the federal decision is made. You tell me, you're a prospective juror. Nobody wants to do jury duty. You've now been selected for the Karen Read case. You find out you're not getting kicked. You found out that you're one of the jurors who are going to sit on this case for the next several weeks. But instead of having to swear and take an oath and be told to head back Monday for opening statements, you're told, by the way, we need you to come back in several weeks, and you have not been sworn. You know what's going to happen in that several weeks time? You're going to get a lot of people who all of a sudden have COVID. A lot of people who all of a sudden have reasons they need to travel. A lot of people who, by the way, I didn't tell you this important thing as to why I shouldn't sit on this jury. It's going to be a mess, mark my words. And I hope we don't get to it, but I think we're just encouraging it by this decision. Again, it baffles and frustrates me. The other thing she did is they asked, the defense did, to be able to state the grounds for their objections on the record. If you remember how this trial proceeded the first time around, all the defense or prosecution could say was objection. And then the judge would make a ruling. And none of us had any idea what the objection actually was. Now, I will tell you, in practice, usually this does not matter. Experienced trial attorneys, experienced judges, everybody usually knows the issues that are coming up and what is being objected to. And the judge can usually make these rulings without actually having to hear the grounds for it. But it really doesn't create that much of a problem to actually state the grounds. And again, it's frustrating to me. It's going to encourage sidebars. It's going to encourage confusion. It's going to create a bad record. It's not like we're reinventing the wheel here either. This is the way it's practiced in most courts across the country, is that you say objection hearsay, objection foundation, objection relevance, objection leading. How am I holding things up? How am I causing confusion? How am I affecting the jury by just stating the grounds for it? I understand a judge shutting down speaking objections. I hate that. I don't think it's good practice when attorneys stand up and start to make an argument in support of their objection. But just merely stating the grounds seems like it's going to make things run smoother, cause less confusion, a better record, and less sidebars, which are quite frankly just a waste of time. All right, I've said my piece. Now let's move on to Trooper Proctor. And this is really the most interesting development, I think, that took place. How bad is this for the prosecution that the lead investigator was terminated by the police department weeks before the retrial on this case, and he was terminated because of unprofessional conduct in regards to this case? Well, it's bad. Now your lead investigating officer has been fired because of conduct directly related to this case. I realize that there were other things mentioned in his disciplinary report, but that's the way it's going to play out. You did a bunch of bad stuff the first time around. Your own employer has now fired you over it, and you still are perhaps going to testify in this case. And this is a case where, by the way, the police already kind of look like clowns. Have we forgot about the red Solo cups? Have we forgot about the grocery bag used to collect evidence? Have we forgot about the leaf blower and everything else that made this entire investigation look like it was run by the Keystone Cops to begin with? And now your lead IO has been fired over conduct related to this case, a case where the defense has made the investigation itself a quote unquote suspect. Yeah, it's bad. And it's also not as bad. It could be worse. The text messages, if Proctor testifies, the text messages are going to come in again. That's already bad. That's where you're starting from, him being fired or not. But at least now you can say, and this is what Brennan will say, and I don't know if this will be convincing to either the jurors or any of you listening, but he will say, at least now the agency, the department, can say that they have distanced themselves from this cancer in this one individual. They have removed this person from their ranks. They've acknowledged that what he did was wrong. I mean, you could see how it would play if they didn't. And then they're going to say, don't throw out the baby with the bathwater. But that is not exactly the argument you really want to be making when you're the prosecution. But what do you guys think? I mean, pick your issue in this case. Is it the documentary? Is it the judge's rulings? Is it Trooper Proctor? What has you the most heated about this case this week? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to ask one very small favor from you, and that is, if you haven't already, please take a moment to subscribe to our channel now. We want to continue to provide you with the highest quality content that we can, and the best way we can do that is through your support. And don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, a Kentucky Army officer has been found guilty of manslaughter in the death of his wife, who was also a ranking officer in the military. Jordan Henning was charged with the murder of Sergeant First Class Ashley Henning on June 26, 2023, her birthday, after the couple hosted friends at their home to celebrate. This week, a jury found him guilty of the lesser charge of first-degree manslaughter, which carries a sentence of 10 to 20 years. Prosecutors allege that once the guests left, Jordan erupted in rage, screaming at Ashley and berating her children. One of Ashley's sons ran to a neighbor for help, but when the neighbor arrived, prosecutors say Jordan threatened them. In opening statements, prosecutors told jurors that home surveillance video captured Jordan shooting Ashley as she pleaded with him to put the gun down. He then reloaded, shot her again, and spit on her body. The defense argued there's more to the story, claiming Jordan was a victim of physical and mental abuse throughout a toxic marriage and simply broke. On Monday, Jordan took the stand, tearfully apologizing for killing his wife. He described years of alleged abuse and the moments leading up to the shooting. Quote, "I don't know who that was," Jordan said, referring to himself in the home security videos. "I've never been like that before." A military psychologist also testified on Monday, telling jurors that in his opinion, Jordan was suffering from extreme emotional distress pushed past his breaking point by repeated triggers. On Thursday, the same jury sentenced Henning to the maximum 20 years in prison. Sean Diddy Combs has pleaded not guilty to an amended indictment that includes new allegations of forced labor. The superseding indictment accuses Combs of forcing employees to work long hours under threats of physical harm and damage to their reputations, and forcing at least one worker into sex acts. Combs' legal team have vehemently denied the claims in both the federal case and dozens of recent civil lawsuits that he has ever forced anyone into sex acts, and insisting the case centers around consensual relationships with his girlfriends. In court last Friday, prosecutors and defense attorneys also debated a video released by CNN last year appearing to show Combs kicking his ex-girlfriend Cassandra Ventura in a hotel hallway in 2016. Combs' lawyers argue the footage is deceptive, claiming a visual expert found it was manipulated, sped up, and out of order. Prosecutors have called the video critical and direct evidence they intend to present at trial. Jury selection in the federal case is set for May 5th, with opening statements scheduled for May 12th. After several days on the stand, the defense's star witness and Monica Sementilli's former lover, Robert Baker, finished his testimony Wednesday. Monica Sementilli is charged with murder and conspiracy in the death of her husband of 20 years, famed hairstylist Fabio Sementilli. Prosecutors allege she and Baker plotted his murder so they could continue their affair and cash in on a $1.6 million life insurance policy. Baker, who previously pled no contest and was sentenced to life in prison for Fabio's murder, denies Monica was part of the plan. He told jurors last week that he killed Fabio because he wanted to be with Monica and, quote, wanted easier access and more time with her. Baker insisted Monica had no involvement and that the third accomplice, Christopher Austin, was only recruited as a lookout. Under cross-examination Monday, when Baker admitted that he didn't know how many lies he told during the investigation, Deputy District Attorney Beth Silverman fired back, "How about 360? At times, he appeared defeated by the grilling and accused Silverman of, quote, trying to feed the jury some crap. Silverman pointed to data showing Monica Sementilli searched for a Vietnamese restaurant the day before the murder, allegedly to lure Fabio there so Baker could follow him. Baker testified he gave an accomplice, Christopher Austin, a knife to commit the murder that day, but their initial attempt failed, forcing them to regroup and move forward with the killing the next day. On the day of the murder, Baker described being nervous as hell as he and Austin snuck into Sementilli's house while the victim was alone outside. Baker added his heart was racing during the frenzied attack and that at some point he blacked out. Sementilli suffered deep wounds to his heart and thigh. Silverman called the attack a, quote, premeditated, planned out murder, adding, "Your plan was to take him by surprise while he was minding his own business on the patio." On Thursday, the defense recalled Austin to the witness stand and jurors heard the audio recording of his proffer interview. Lawyers for Luigi Mangione, the accused shooter of United Healthcare CEO Brian Thompson, claim police violated his constitutional rights by using snacks to collect his DNA. Mangione's Pennsylvania attorney Thomas Dickey argues that after Mangione was arrested at a McDonald's in Altoona, police brought him to the station and gave him snacks, which were then used to obtain his DNA without a warrant, violating his Fourth Amendment rights against unreasonable search and seizure. Quote, "All DNA samples, profiles, etc., were poisonous fruits obtained in violation of the protections afforded the defendant by the constitutions of both the United States and this Commonwealth." Prosecutors maintained they had probable cause to arrest Mangione after questioning him at the McDonald's about any recent trips to New York. According to police, Mangione began shaking, which they found suspicious, prompting them to bring him to the station. Mangione's lawyers have asked the court to exclude this evidence. A ruling has not yet been made. Mangione is facing charges in 3 separate cases, one in Pennsylvania for possessing an illegal gun and giving a fake ID to the police, one in New York State for murder, and a federal case that also charges him with murder. Mangione is scheduled to appear in federal court in the Southern District of New York on April 18th. Joshua Reeby, the key witness in missing college student Sudiksha Kunanki's disappearance, reportedly left the Dominican Republic on Wednesday. Reeby is believed to be one of the last people to see Kunanki before she vanished early March 6th, from the beach behind the resort in Punta Cana. On March 18th, following the conclusion of a habeas corpus hearing, the prosecutor's office informed Ribe of their readiness to return his passport. Ribe's attorneys issued a statement saying, quote, "While Joshua appreciated the decision, he chose for privacy reasons to apply for a new passport at the U.S. consulate, which was promptly issued. We are pleased to announce that Joshua and his father are currently traveling back to their home in the United States." Ribe's departure from the country comes a day after his attorneys successfully argued that police unlawfully restricted his movements for 11 days despite his status as a witness, not a suspect. A Dominican judge ruled in Ribe's favor, giving him the ability to move freely within the country until another hearing on March 28th. Ribe had been confined to the resort under strict police watch. His cell phone and passport were both confiscated. Surveillance video shows Ribe and Kananke heading to the beach with a group around 4:15 a.m. on March 6th. Most of the group were later seen returning around 6 a.m., but Ribe and Kananke remained. Ribe returned alone hours later. Kananke's whereabouts remain unknown nearly 2 weeks later. According to a leaked police interview transcript, Ribe told investigators they were both pulled away from the shore by a strong current and struggled to return. He last saw her walking in knee-deep water before he vomited and fell asleep on a beach chair. Kananke's parents requested authorities to have their daughter declared dead earlier this week, citing the lack of evidence of foul play and Ribe's continued cooperation with investigators. So-called doomsday mom Lori Vallow told an Arizona judge Tuesday she's determined to stand trial for murder as scheduled on March 31st, even if her defense is not ready. Vallow is already serving life in prison in Idaho for murdering her two youngest children, J.J. Vallow and Tylee Ryan, and conspiring to kill her fifth husband's first wife, Tammy Daybell. Now in Arizona, she's acting as her own attorney in two separate cases. First, the murder of her fourth husband, Charles Vallow, followed by charges of conspiring to kill her niece's ex-husband, Brandon Boudreaux. Jury selection for the murder trial begins March 31st. In court Tuesday, Vallow appeared with advisory counsel and Maricopa County prosecutors to address discovery issues and trial logistics. She indicated she may testify and plans to call East Idaho news reporter Nate Eaton as a witness. Vallow also requested a digital forensic expert examine Charles Vallow's phone and other evidence she claims she hasn't received from prosecutors or her former attorneys who withdrew from the case earlier this year. Superior Court Judge Justin Bareski warned Vallow, quote, "You're the one pressing for your speedy trial, so you kind of have to make a decision. You want to go to trial or have the work you want, because I don't think both are going to happen. This is one of the things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done." Vallow insisted she wanted to proceed as scheduled, even if the expert's investigation isn't finished or admitted at trial. During discussions of jury selection, prosecutor Trina Kay noted there's no way to avoid mentioning JJ, Tylee, or Vallow's prior convictions while ensuring potential jurors are properly screened for bias from pretrial publicity. She said the state will question jurors directly about their knowledge of Vallow's Idaho case to assess any impact on their impartiality. The parties are due back in court on March 31st to begin discussions on the jury questionnaire responses. Before we get to what's on the docket for next week, I want to take a moment to thank you all for being part of our growing community. But I wanted to give a special shout out to Love Weather Kitty for their fantastic review on Apple Podcasts, and as well to our CC crew members, Deb in Indiana and Forrest Nelson, for their support on YouTube. Keep them coming. We absolutely love hearing from you. And please tell us where you are from. We're thrilled by the growth of our international Courtroom Confidential community. On the docket for next week, Florida matriarch Donna Adelson is set to return to court for a case management hearing on Tuesday, March 25th. Adelson is accused in the murder-for-hire plot of her former son-in-law, Dan Markell. Victoria Goodwin, the Nevada woman charged with plotting to kill her husband, Ghost Adventures star Aaron Goodwin, will be back in court on Tuesday, March 25th for a preliminary hearing. Kimberly Sullivan, the Connecticut woman accused of keeping her stepson locked in a room for 20 years, is due back in court on Wednesday, March 26th. Suspected Gilgo Beach serial killer Rex Heuermann will return to court Friday, March 28th for a Fry hearing to determine what DNA evidence will be admissible during trial. Shanna Gardner, the Florida woman accused of plotting to have her ex-husband Jared Britigan killed in 2022, will be back in court on Friday, March 28th for a pretrial hearing. And finally, please join us on our YouTube channel this Monday for the latest episode in our Courtroom Confidential Conversation series when we sat down with Derek Levasseur of Crime Weekly. Join us live in the chat for the premiere on Monday at 5 p.m. Pacific, 8 p.m. Eastern. And that is it for us this week, folks. I am your host, Joshua Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.